40 real estate test question compilation. This video is going to be broken up into 10 questions, and then 20 questions related to the laws of agency. If you could do me a huge favor, it would be so helpful if you could just drop a comment letting me know if you like the 10 question videos, the 20 question videos, or these 40 question videos the best. Or you could even let me know a different number of questions and a specific topic that you want me to give you test questions on. Okay, let's dive into these first 10 questions. Question number 1. When an agent does not disclose that they are representing the seller in an ad, the agent may be guilty of which of the following? A. Permissible advertising. B. Deceptive advertising. C. Blind advertising. D. False advertising. The answer is C. Blind advertising. Now, no, that is not that you are advertising to blind people. Blind advertising just means that there's non-disclosure by an agent in an ad. Don't get caught doing this because other agents might try and get you fined. Question number 2. While at an open house, the listing agent encounters an unrepresented buyer. The agent is asked by the buyer to prepare an offer to purchase. At the meeting to prepare the offer, the agent tells the buyer, "I'm sure I can get the seller to agree to this price and get the financing you need." What has the listing agent just done? A. Being a good fiduciary to the client. B. May have created an implied agency. C. Has done nothing inappropriate. D. Made the seller very happy. The correct answer here is B. May have created an implied agency. Agents must be very careful about what they say to customers. If an agent appears to be the agent of the buyer as well as the seller, they may become a dual agent. Now, keep in mind, in some states, dual agency is legal. In some states, it's a no-no. So understand the laws of your state. Question number 3. An agency disclosure is necessary in order to A. Let the client know that the agent represents him. B. Let the buyer know that the agent represents the broker. C. Let the seller know that the agent represents the broker. D. Let the customer know that the agent represents him. Correct answer here. A. Let the client know that the agent represents him. The agency disclosure form lets a client know who represents them. A customer is not represented by anyone. The agency disclosure does not discuss the relationship between the broker and the sales agent, but discloses the relationship of the broker/brokerage to the seller rather than the buyer. Question number 4. Jake lists a property. Jake finds a buyer. Is Jake allowed to write an offer as a buyer's representative? A. No, an agent cannot collect both commissions. B. Yes, as long as both parties agree to it in writing. C. Yes, if it is specifically written in the offer. D. No, it's against federal trade laws. Correct answer here is B. Yes, as long as both parties agree to it in writing. Now, this one is specific to California because in California, dual agency is allowed. In some states, it is not allowed. So make sure you know the specific laws of your state. Question number 5. While a listing agent is showing some rental property, it becomes clear that the buyers are about to disclose a confidentiality. They recently won a large settlement in a personal injury case and have unlimited funds to spend on the property. The agent, A, is a dual agent, so it's okay if the buyers tell the agent this info. B, owes no duty to disclose to the buyers any relationship between the agent and the seller. C, is a buyer's agent and will keep the buyer's confidentiality. D, should tell the buyers, before showing any property, not to disclose any confidentiality. Correct answer here is D, should tell the buyers, before showing any property, not to disclose any confidentiality. And here's why. As the buyers are about to tell the sales agent a confidentiality, the agent should tell the buyers before any home is shown that the agent represents the seller and that all information disclosed to the agent will be told to the seller. And in this question specifically, the agent is the listing agent and is not the dual agent, so they do not represent the buyer. Simply showing a buyer a house does not make one an agent of the buyer. So we've gone through 5 questions. If you like these questions and you want more of them, I highly recommend buying a test bank of questions for yourself, a exam prep. So I've actually shared an affiliate link to Calibri. They are the education provider that I've used for all of my licenses. Obviously, if you want to pass the exam on the first try, you want to have the best study prep. Many viewers on my channel have taken this advice and passed on their first try. I want to see you succeed and pass on your first try. Let's get back into the questions. Question number 6. A sales agent is selling their own personal property, the condition of which they misrepresent. The agent is sued and raises the defense that they were not acting as an agent in this sale, but rather were selling their own property personally. The probable outcome of the case is A, the sales agent will win. B, the broker will be liable. C, the sales agent will be held liable. D, the case will be dismissed for no cause of action. Correct answer here is C, sales agent will be held liable. Real estate agents are subject to the rules of professional ethics 24/7, 365. So whether you're selling a property for someone else or you're selling your own property, you as an agent are not going to be relieved of these professional ethics duties. Question number 7, a principal dies. The agent is not aware that the principal has passed away and continues to act on the behalf of the principal several days past the principal's death. Which statement is true? A, the agency relationship has been renounced by the agent. B, any representations or contracts entered into by the agent on behalf of the principal are binding upon the principal and or the principal's estate. C, the agency relationship has been revoked by the agent. D, any contracts or representations made by the agent are void since the principal has already died. Correct answer here is B. Any representations or contracts entered into by the agent on behalf of the principal are binding upon the principal and or the principal's estate. In general, an agency relationship is terminated only if the agent actually knows of the seller's death. Question number 8. An attorney, in fact, is best described as A, fiduciary to his principal. B, an attorney at law. C, a power of attorney. D, a principal. Correct answer here is A, a fiduciary to his principal. And here's why. So an attorney, in fact, receives authority under a power of attorney and need not be an attorney at law. An attorney, in fact, is an agent for the principal and thus owes the principal all fiduciary duties. If you don't know what fiduciary duty means, that's cool. It just means that the person representing someone else needs to look out for that other person's financial interests. Question number 9. The death of the broker or principal, incapacity, insanity, or bankruptcy of the principal are all ways agency can be terminated by A, full performance. B, expiration of its term. C, operation of law. D, acts of the parties. Correct answer, C, operation of law. So in the event of a death, incapacity, insanity, or bankruptcy, the agency relationship automatically ends by operation of law. This means the termination occurs legally without requiring any action from either party. Question number 10. An agency relationship should be created by which of the following methods? A, implication. B, expressed written agreement. C, estoppel. D, ratification. Correct answer here is B, expressed written agreement. So if you just understand what all of these terms mean, you're going to be able to answer this question easily. So estoppel refers to a parent agency, which occurs when someone allows another to act as their agent without actual authority. Ratification happens when an agent's act is accepted after it's already been performed. And implication can establish an agency relationship through conduct, but it's not the preferred or formal method. So that leaves us with expressed written agreement. So because I care about you and I want to see you pass your exam on the first try, I'm giving you a bonus question. Question number 11. The best description of principal is A, an owner of real estate. B, a customer. C, a landlord. D, one who employs a broker to represent their interest in matters of real estate. Correct answer, D, one who employs a broker to represent their interest in matters of real estate. Once again, if you just know these definitions, these questions are super easy. So when you're studying, go through those chapter summaries at the end, make sure you know your definitions, and these questions will be a slam dunk for you. Okay, next 10 questions. Question number 1, what would be a violation of agency? A, the agent does not reveal any confidential information to either client. B, the agent gets the informed consent to act as a dual agent. C, the agent discloses to the buyer what the seller is willing to accept. D, the agent does not advocate for either buyer or seller. So what are you doing as an agent? Correct answer here is C. The agent discloses to the buyer what the seller is willing to accept. So the reason why this is the correct answer is that if you're an agent and you're acting as a dual agent, which means that you're representing both the buyer and the seller, you can't give any information to either party to make an unfair advantage. Question number 2. What would one calling a selling agent who is not the listing agent? A, a general agent. B, a seller's agent. C, a cooperating agent. D, a universal agent. I think all of us are D, right? I think all of us are universal agents. We want people to do well. But the correct answer here is C, cooperating agent. A listing agent is the agent who represents the seller, and the selling agent is the cooperating agent, meaning they represent the buyer. Question number 3. An agent realizes that one of the houses in their routine farm area would be a good fit for their buyer customer. The agent gets the seller to agree to pay their broker a commission if the buyer makes an acceptable offer. What kind of agency has been created if no listing agreement was entered into? A, agency by ratification. B, agency by estoppel. C, agency by agreement. D, ostensible agency. Correct answer here is A, agency by ratification. So because there was no listing agreement, the relationship is created by the seller accepting the benefits of the relationship, which is also known as ratification. Question number 4. When two brokers are working with the same buyer, which broker will have earned the commission? A, broker of procuring cause. B, listing broker. C, second broker to make contact with the buyer. D, first broker to make contact with the buyer. Correct answer here is broker of procuring cause. So if two brokers are working with the same client and neither of them knows that, the broker that presents the accepted offer to the seller is actually the procuring cause, which allows them to earn the commission. Really important to know this term, procuring cause. Basically just means you're the reason why this buyer ended up buying a property, which would enable you to earn the commission. Question number 5. What is impossible for a listing agent to do? A, represent a buyer only. B, be a dual agent. C, represent a buyer and seller. D, represent the seller only. A, represent a buyer only. If you understand the term dual agent, that means you represent both parties. This is legal in California. It's not legal in all states. But the term listing agent means that you represent the seller. So just by understanding dual agent and listing agent, you can know the answer to this. Now that we've gone through 5 of the 10 questions, if you've enjoyed studying with me and you like these questions, I get all of these questions from an exam prep called Calibri. I've used that platform to pass my real estate exam and loan license officer exam on the first try. I've also partnered with them, so I'm going to share an affiliate link if you want to buy your own education or exam prep. Just know, full disclosure, you are supporting my channel. I get a small portion of the sale. So if you want to maximize and pass in your first try, I highly recommend checking out that link. If not, totally cool. Let's keep studying together. Question number 6. What event does not terminate or dissolve an agency? A, death of listing agent, not broker. B, destruction of listed property. C, expiration of term. D, full performance. Correct answer here is A, death of the listing agent, not the broker. So real estate agents hang their license with brokers, and technically the broker owns the listing. So if the listing agent passes away, that broker still has the right to list that property for the seller. Now, if the broker passes away, then that would terminate the agency. Question number 7. Under common law, an agent's fiduciary obligations to his or her client include A, communication, obedience, loyalty, agency, and notice. B, communication, obedience, loyalty, and confidentiality. C, concern, discretion, accountability, and loyalty. D, care, obedience, loyalty, accountability, and notice. Correct answer here is D, care, obedience, loyalty, accountability, and notice. An easy way to remember this is colon, C-O-L-A-N. Question number 8. Under California's workers' compensation law, the broker is responsible for A, salespeople, B, clients and employees. C, employees and salespeople. D, employees. Correct answer here is C, employees and salespeople. So in regards to workers' comp, brokers are responsible for both clerical employees and salespeople. California's got those tough employment laws, huh? Go ahead and drop a comment and let me know what state you're in. These questions are pretty specific to California, but in the future, if I get a lot of comments saying you're in a different state, I'll try to make videos that have questions that are geared for the national test. Question number 9, fiduciary applies to the relationships between people in many different positions. It does not apply to which of the following? Make sure you read these questions carefully. It's really easy to miss the ones that ask you not questions. A, attorney to client. B, agent to seller. C, trustor to beneficiary. D, attorney in fact to principal. Correct answer here is C, trustor to beneficiary. Fiduciary means that it's an agency relationship. Trustor to beneficiary is borrower to lender. Question number 10, last question. A licensed real estate salesperson is permitted by law to represent A, an interested party. B, one or more brokers. C, themselves as a broker. D, they're sponsoring broker only. Correct answer here is D, they're sponsoring broker only. So a licensed real estate person works for their broker only and acts on behalf of their broker as a sub-agent to buyers and sellers. So a salesperson is required to hang their license with a broker. And that means their responsibilities and their authority comes from that broker as well. Thanks for sticking around to the end of this video. I hope it helped you a lot. But I got a surprise, a bonus question, question number 11. A buyer-broker agreement cannot be A, novated, B, assigned, C, executed, D, performed. Correct answer here is B, assigned. And so it's really important that you know the definition of each of these 4 words, but basically an exclusive buyer-broker agreement is just like a listing. It is a service agreement between you, the agent, and a buyer, and it cannot be assigned to a different agent. Now let's finish up the video with the last 20 questions here. Question number 1, an agency relationship should be created by which of the following methods? A, ratification. B, implication. C, express written agreement. D, estoppel. Correct answer is C, expressed written agreement. An agency agreement should be created by expressed written agreement. The term estoppel refers to a parent agency, which is just created when a person allows an agent to appear to be the agent of that person without any actual authority. Ratification is the acceptance of an agent after the performance of the act. And implication is used to create an agency relationship by a party's conduct where no expressed agreement exists, aka get it in writing. Question number 2. A real estate agent in a sales transaction is referred to as what type of agent? A, limited agent. B, universal agent. C, special agent. D, general agent. The correct answer here is C, special agent. Question number 3. A relationship between one person, a principal, and another, an agent, wherein the agent is given the right to act on behalf of the principal in a business setting is usually called A, trespass. B, agency relationship. C, customer representation. D, involuntary servitude. Correct answer here is B, an agency relationship. Question number 4. When 2 brokers are working with the same buyer, which broker will have earned the commission? A, first broker to make contact with the buyer. B, the listing broker. C, the broker of procuring cause. D, the second broker to make contact with the buyer. Correct answer is C, broker of procuring cause. So procuring cause is actually a very important term to understand. Basically means you as the agent were the reason why this property sold, and thus you would be entitled to earning the commission. Question number 5. One who acts or has the power to act for another is termed A, agent. B, principal. C, customer. D, client. Correct answer is A, agent. I highly recommend you know what each 4 of these terms mean, because you will probably see a question that if you just know what these words mean, you'll get it right. Question number 6. During a listing interview, a seller demands that the listing agent reduce the proposed commission by 1%. What is the best course of action for the agent? A. Refuse the listing as commissions are not negotiable. B. Go ahead and reduce the commission. C. Explain that commissions are generally fixed in each locality. D. Call the broker and discuss the matter. The correct answer here is D. Call the broker and discuss. So keep in mind, real estate agents hang their license with a broker, and each broker may have their own rules or guidelines that the agents need to abide by. And so agents shouldn't be just adjusting their commissions without the consent of their managing broker. Also, keep in mind, commissions are negotiable between broker and seller or buyer. Question number 7. While at an open house, the listing agent encounters an unrepresented buyer. The agent is asked by the buyer to prepare an offer to purchase. At the meeting to prepare the offer, the agent tells the buyer, "I'm sure I can get the seller to agree to this price and get the financing you need." What has the listing agent just done? A. May have created an implied agency. B. Has done nothing inappropriate. C. Is being a good fiduciary to the client. D. Made the seller very happy. Correct answer here is A. May have created an implied agency. So let's break this one down. You, the listing agent, is representing the seller. So obviously, you're not being a good fiduciary to that client. If you're telling a buyer like, hey, we can just get this done at this price, you probably aren't making the seller very happy because that price may or may not be what the seller really wants. Let's just say agents need to be careful about what they say to potential customers. So I'm in California. You're actually allowed to be a dual agent and you can represent both buyer and seller. In some states, it's illegal. Question number 8. A month after taking a listing, the listing agent decides that they want to make an offer to purchase the listing. What special agency disclosure is required? A. That the agent will now be a dual agent. B. That the agent will continue to represent the seller. C. That the seller is no longer represented and should seek representation. D. No additional disclosure is required. The correct answer here is C. That the seller is no longer represented and should seek representation. When a listing agent takes a listing, they now agree to represent the seller. But if the agent decides to buy the listing, they're no longer representing the seller and must disclose this to the seller. And they should suggest to the seller that they get their own representation or represent themselves. Question number 9. An agency relationship can be terminated legally without recourse under which of the following circumstances? Oof, morbid. A. When the listing broker dies. B. When the listing salesperson dies. C. When the salesperson becomes mentally incompetent. D. When the buyer dies. Correct answer here is A. When the listing broker dies. So keep in mind, I mentioned this before, real estate agents hang their license at a broker. The broker of record is actually the person responsible for that listing. And so if the listing broker dies, that would make the listing agreement void. Question number 10. While a listing agent is showing some rental property, it becomes clear that the buyers are about to disclose a confidentiality. They recently won a large settlement in a personal injury case and have unlimited funds to spend on the property. The agent is A, a dual agent, so it is okay if the buyers tell the agent this info. B, is a buyer's agent and will keep the buyer's confidentiality. C, should tell the buyers before showing the property not to disclose any confidentiality. D, owes no duty to disclose to the buyers any relationship between the agent and the seller. Correct answer here is C. They should tell the buyers before showing them the property not to disclose any confidentiality. So in this question, the agent is actually the listing agent, meaning they represent the seller. They don't have any agreement in place with the buyers. Their job is to represent the seller. So any info the buyers disclose will be told to the seller. All right, we're halfway through these 20 questions. If you've liked these questions so far and you want to purchase your own test bank of questions, there is a link in my description. Full disclosure, it's an affiliate link. So if you decide to purchase test material that will help you pass your exam, I do get a small portion of that revenue, and thank you for supporting my channel. I wouldn't put it there if I didn't actually believe in the product. Okay, let's dive back into these questions. Question number 11. A licensee who has both a listing and the option to buy must inform the principal of which of the following? A, how much the web page cost. B, agency relationship. C, the amount of profit the licensee will make. D, how much the ads cost. Correct answer here is C, the amount of profit the licensee will make. Question number 12. A competent and disinterested person who is authorized to act in another's place is called A, a broker. B, an agent. C, a dual agent. D, attorney in effect. Correct answer is D, attorney in fact. So an attorney in effect is not an attorney at law. An attorney in fact has been given the power to act for someone else. That's all it is. Just got to know the definitions of these words, like I said previously. Question number 13. A listing agent works for the seller. A buyer's agent works for the buyer. What responsibility does a licensee have to the other agent's party? A, the agent owes the first duty of allegiance to the other party. B, the agent must treat all parties to the transaction honestly and fairly. C, the agent must keep the other party's confidential information from his or her own principal. D, there's no responsibility owed to another party, as agents' duties are owed only to their principals. Correct answer here is B, agent must treat all parties to the transaction honestly and fairly. Question number 14. Fiduciary applies to the relationships between people in many different positions. It does not apply to which of the following? A, truster to beneficiary. B, attorney in fact to principal. C, attorney to client. D, agent to seller. Correct answer is A, truster to beneficiary. Fiduciary is an agency relationship, while truster to beneficiary is a borrower to lender relationship. Question number 15. Which of the following is the best example of a special agent? A, universal power of attorney. B, real estate licensee. C, property manager. D, limited agent. Correct answer is B, real estate licensee. Now, by definition, a special agent is someone who has very limited authority and may only do one thing for the principal. For example, find a ready, willing, and able buyer for their property, or represent them in the purchase of a home. Now, a universal agent may do anything for the principal, and a general agent is an agent who may do anything in one particular area. So in this example, the property manager would be a general agent. And limited agent, that's just in there to try to trick you. That's not anything. Question number 16. An agency disclosure is necessary in order to A, let the client know the agent represents him. B, let the customer know that the agent represents him. C, let the seller know that the agent represents the broker. D, let the buyer know that the agent represents the broker. Correct answer here is A, let the client know that the agent represents him. Now, this one's a little bit tricky because it talks about client and customer. So make sure you know the difference in what a client is and a customer is. Customers are not represented by anyone, while clients do have representation. Question number 17. The best description of principal is A, an owner of real estate. B, a landlord. C, one who employs a broker to represent their interest in matters of real estate. D, a customer. Correct answer here is C, one who employs a broker to represent their interest in matters of real estate. Question number 18. An attorney in fact is best described as A, power of attorney. B, a principal. C, a fiduciary to his principal. D, an attorney at law. Correct answer here is C, a fiduciary to his principal. As mentioned before, make sure you know the definitions of these words. Half the battle is just knowing what the question is asking and knowing what the words mean. Question number 19. Under California's workers' compensation law, the broker is responsible for A, salespeople, B, employees, C, employees and salespeople, D, clients and employees. Correct answer here is employees and salespeople. Question number 20. What is impossible for a listing agent to do? A, represent the seller only. B, represent a buyer only. C, be a dual agent. D, represent a buyer and seller. Correct answer here is B, represent a buyer only. So a listing agent is someone who has an agreement with a seller to sell their property. And in California, agents are allowed to be dual agents. So you could be a listing agent and dual represent. So C and D are basically the same answer, which leaves us only with B. So we've made it through these 20 questions. If you've made it this far, thanks for staying with me. Because you've made it this far, I want to reward you with a bonus question. Question number 21. An agent realizes that one of the houses in their routine farm area would be a good fit for their buyer customer. The agent gets the seller to agree to pay their broker a commission if the buyer makes an acceptable offer. What kind of agency has been created if no listing agreement was entered into? A, agency by ratification. B, agency by estoppel. C, ostensible agency. D, agency by agreement. Correct answer here is A, agency by ratification. Because there was no listing agreement, the relationship was created by the seller accepting the benefits of the relationship. And this is known as ratification. Now that you've gone through all 40 questions, I hope you're an expert on the laws of agency. If you have any specific questions about the real estate exam or life as a real estate agent, here's my email. You can reach out to me directly. I'd love to help you in your real estate career. And as always, thanks for watching my videos, and I hope you pass your exam on your first try.